My warm gratitude to all of you who traveled so far to come here and join us for here, to exchange your thoughts, to learn more. So first, let us start this with gratitude. I hope you all are having a great time here in this beautiful city of Bangkok, which is full of life, full of people, and of course, good food. And yes, yesterday was, it is a good start to this event, and I'm sure it's going to be very good. A lot of things that we can learn from here. I still believe that people had really good time yesterday, and most of them are still busy with the breakfast or probably join us later. But meanwhile, we can start our own discussion since all of us are here already. I would like to welcome all of you. With us, we have our moderator, Mr. Yuri. Can we just give him a huge round of applause? He will be moderating the session. And with us we have Mr. Rybchak and Mr. Levchuk. I think that's the right way of pronouncing your name. Can we give them a huge round of applause? And with us we have Eduard. Let us give him a huge round of applause also. And that's about it. The topic that we are going to discuss is about EuroAsian IP System. So since we don't have a lot of people with us, so it'll be a closed discussion. So open for questions, open for discussions, and I think with this you should start. And so you will be taking care of the slides. You can just tell him and he will help you with the slides.
Yes. So thank you very much for the excellent introduction. We have recording here, so please all the speakers know that the recording is ongoing, and well, we start with the topic on regional system of protection, which is EuroAsian system. The EuroAsian system within 3 years will celebrate its 30th anniversary. So it was established in the year 1995 as a sort of substitution for the former Soviet Union patent system, which united 15 republics of the Soviet Union that in the middle of 1991 and completed the process in the end of 1991 became independent states. However, only Russia was that time inherited the Soviet system in this sense that the patent office existed in the territory of the Russian Federation, and the new republics were to establish their own systems. And what they did, by the way, and concurrently to this process, the system of regional protection was developing. It was clear that three former republics, three new states went to the European patent system, the Baltic states, and other remaining 12 were discussing what should they do to substitute, and the idea of EuroAsian system appeared, which was joined by not all 12, but that time 9 of the countries, and after several years ago Moldovan denunciation of EuroAsian Convention, now we have 8 states being in the EuroAsian system. The EuroAsian system originally was about patents for inventions, and its model was very close to what was first suggested for European system as community patent, but then the community patent became a long on hold story, and the European patent system appeared on another basis. The EuroAsian system in much was, I would say, modeling European system, with the only difference that was inherent for community patent, and which is now the reality for unitary patent, meaning that after being granted, the EuroAsian patent needed no validation in member states and became valid in all those member states by simple paying annuities. In all other respects, the system was very close to what you know from the European patent system. In year 2019, the Eurasian system was expanded to industrial designs. Starting from 1st of July 2021, the Eurasian industrial designs are due, so the same Eurasian Patent Office accepts applications for industrial designs, and we will hear today two presentations on this topic, the general presentations on what the Eurasian industrial designs are, and excellent comparison of three systems, the regional system, the Eurasian system, the Haki system, and national system of the Russian Federation, to more illustratively see the differences and advantages of any of the systems. So I think we can start. Just a few words about the plans of further expansion of the Eurasian system. There are three ways in which Eurasian system expectedly will move in certain sequence or maybe concurrently. First is rethinking of admissibility of more than one language as the language of Eurasian patent. Because up to now this is only Russian language is working and the language of the patent, with possibility of demanding its translation into national languages when patent is enforced. As I think our third speaker, Eduard, will tell more about that. And expansion over new objects, new subject matters, which expectedly are trademarks. And then the Eurasian, let's say, very official Eurasian Patent Court, which is another idea now which is discussed, and the certain preparations are made. So we'll start with the regional system of protection of trademarks and designs in Eurasia. Trademarks is not a misprint. It's not the Eurasian trademark in the sense that it is granted by Eurasian Patent Office. It's about so-called Eurasian Economic Union trademark, a treaty which was signed. I think we will discuss this matter and talk over its advantages and definite disadvantages, if you may allow me this spoiler already. So we start, and Viacheslav, please, it's your time. I think if we fix 20 minutes for each speaker, we will be on time.
Thank you, Yuri. Probably you will already change the slide. So I'm pleased to welcome all of you today at our seminar dedicated to the protection of intellectual property in the Eurasian region. One of the most important trends of development of the intellectual property field is the development of regional systems of protection of different kinds of intellectual property, and in particular of trademarks and designs. And today I will speak about the Eurasian trademark system and separately about the Eurasian design protection system. So let's start with the Eurasian trademark system. I must say that this system is supposed to provide the possibility to obtain registration for a Eurasian trademark. However, as Yuri already said, this system is not functioning yet. It is expected to be launched in the near future, probably already by the end of this year, or probably in the beginning of the next year. However, it is already interesting to see some key features of this system. So, in general, there are the following ways for companies, for applicants, to how to obtain trademark registration in the Eurasian region. The first way is filing of a national trademark application in a concrete country in Eurasia. The second option is the possibility to use the Madrid system of international registrations with designation of respective Eurasian countries of interest. And the third option, which is expected to be available soon, is the regional system of Eurasian trademark. Please, next slide. The governing law for the Eurasian trademark system is the Treaty on Creation of the Eurasian Economic Union. I must say that the Eurasian trademark is supposed to be launched in frames of the Eurasian Economic Union. Actually, the Eurasian Economic Union is composed of 5 countries. It's Russia, Belarus, Armenia, Kyrgyzstan, and Kazakhstan. So it is supposed, by the way of filing of a single trademark application, there will be the possibility to obtain a Eurasian trademark, which will be valid on the territory of all member states. So the countries, the member states of the Eurasian Economic Union adopted in 2020 a treaty on Eurasian trademarks, service marks, and appellations of origin of goods. This treaty provides legal regulation for obtaining a protection of trademarks and appellations of origin of goods. But it is clearly stated that the provisions do not apply to certification marks, to guarantee marks, and to designations which cannot be represented graphically. And furthermore, there is also an instruction to this treaty which provides the detailed regulation of the procedure and for the examination of Eurasian trademark. Like other jurisdictions, Eurasian trademark is considered as a sign capable to distinguish goods and services of one person from the ones of another person, and it's provided that the designations, including but not limited to verbal, device, three-dimensional or combined, can seek protection as Eurasian trademarks. It is also provided that a Eurasian trademark can be registered in any color or color combination. It is also possible to claim protection for so-named non-traditional trademarks, but provided that they can be represented graphically. It is also supposed that the Eurasian trademark, if registered, enjoys protection on the territory of all member states. One of key features of the Eurasian trademark system will be the fact that this system does not provide for a unified multinational IP office like European IP office. Instead, it is provided that an application, a trademark application for Eurasian trademark, can be filed with any of IP offices of any member states, and the IP office through which the application is filed will become a filing IP office, and the IP offices of other member states, they will work in close collaboration by examining the Eurasian trademark application. And there's also an important moment is also that it is not required to have a basic registration or application in order to apply for a Eurasian trademark, like in the Madrid system of international registrations. Next slide, please. The Eurasian trademark system is based on the first to file principle. This means that first who applies for Eurasian trademark will become the priority right to obtain registration. It is also important and it's also required to proceed with filing without delays, even the applicant does not intend to use the Eurasian trademark in all or in any member state right now. And it's also important because the Eurasian trademark system does not provide prior use rights. So, in order to file an application for Eurasian trademark, it is not required to submit any evidence of use or intent to use. The trademark, as I already said, can claim protection in any color or color combination. However, I must say that a trademark, if registered in a particular color, will not automatically cover any other colors or color combinations. And the same concerns the use of scripts. For example, a Eurasian trademark in Latin will not automatically cover any other scripts. It is also possible for Eurasian trademarks to claim multiple priority based on several trademark registrations of the same applicant in other countries of the Paris Convention and for different goods. The term of validity of the Eurasian trademark is provided as 10 years. It can be renewed unlimited number of times for further 10 years.
Gentlemen, just one thing to comment. We have 1 man in our auditorium, which is worth 200 or 300. We have honorable judge right over here.
Do you have to pay a new fee every 10 years?
Yes.
How much is that?
In the beginning, I explained that the Eurasian trademark system is not functioning yet, and one of the reasons why it is not functioning yet, the fact that the member states of the Eurasian Economic Union still have to agree on fees, on the amount of fees, in order to start to launch this system. Therefore, we just speak about the system which is supposed to be launched in the nearest future. However, there are some moments, some documents that should be still adopted by the member states in order to let this system started.
May I just step back, because I would very much like opinion of Mr. Rader regarding the, I would say, vitality of this system, because this system, which is named Eurasian Trademark System, was certainly planned to be balanced between the participating offices. So there is no one which is the central. And it means that each of five patent offices should be ready to receive new applications, and then to send this application to all members to do first round of examination, then all send it back, and the next round of examination is planned, and then again. So as for me, I may be wrong, but for me it's a rather difficult system, because for the patent offices, the first, because you cannot plan the load. You don't know to which patent office the applications will come, but you need to have people sitting and waiting them.
Well, what happens if you have a likelihood of confusion in one of the jurisdictions and not the other four?
It becomes, I would say, this becomes the problem or the bar for getting protection in all. So that, to me, exactly as you mentioned, to me it diminishes all the value of the system.
I can add that
yes.
In case, so I will tell it a bit in more details further, but I can tell right now that every IP office of member states will conduct a substantive examination in case an IP office of any member state reveals some bars to registration. So it will make a respective conclusion and send it to the filing IP office, and the filing IP office will issue a provisional refusal based on the conclusion of the IP office of a member state. So then it will be possible for the applicant to respond and to submit arguments. The refusing IP office will consider the arguments and still decide whether to grant registration or not. In case it is still not granted, there will be the possibility to appeal the refusal with the refusing IP office. the system is rather complicated, however, we hope that it will work.
Yes, for me it's overcomplicated. I mean, it's extremely complicated.
So probably the previous slide.
Yeah, that was the procedure.
This is the procedure.
Wouldn't there be some system where you could restrict your rights to a geographic area? That happens even within states in the United States. We can have geographic restrictions on the trademark protection based on past use and expectations. Could that happen here? Kazakhstan, you get coverage because of the secondary meaning, but you don't in Russia.
The Eurasian trademark system does not provide for prior use rights. Therefore, as I already said...
But for restriction, when, let's say, appeal is not successful with a particular office, like, one out of four.
In case the application is not successful as a Eurasian trademark, in this case, there will be the possibility to transform the Eurasian trademark application into national applications of the respective member states, per choice of the applicant. So, and the procedure is, I cannot say that it's so complicated, but probably the examination procedure is rather complicated.
It's complicated on this side of the patent offices, this is for sure.
So an application can be filed with an IP office of any member state. So this IP office becomes filing IP office, and it conducts the preliminary examination. In case the result of preliminary examination is positive, so the filing IP office proceeds with publication of the trademark application, and from this date of publication starts the opposition period. And
can you show us the 5 again and tell us why those 5 and not some other neighboring states? I see Kazakhstan, where's Uzbekistan, Tajikistan, and so forth.
Sorry.
Because it was made based solely on the member states of the Eurasian Economic Union. And it was the idea of the Eurasian Economic Commission to have that. So it's like if European Commission decides to have its own trademark and or issue on patents. So it's and the Eurasian Commission, it doesn't have any bodies like Eurasian Patent Office like in Europe. They don't have European Patent Office. It's a body of European system. And this is why they decided that each of the patent offices should be capable to become the so-called first filing office for this system, or the system where the application is filed and which governs then all the manipulations within the procedures. So it becomes a sort of, logistic body. Also conducting own examination. And as you perfectly mentioned, and what is the result? If you skip one, that means you return to national proceedings, or at least to the possible international trademark registration. So here, me personally, I see here lots of complications. And as I mentioned on the side of the patent office, because you can't plan the load. You may have, you should be potentially ready to receive applications like, for example, Armenian patent office, which is not large. But who knows, applicant can file at anyone. And having, let's say, 40 people reserved, which will be almost the whole staff of the Armenian patent office, expecting that someone will file, but probably none, makes this story very complicated. And as a result, to then transform to the national ones, well, too complicated a system. So, Viacheslav, we should move rather fast forward.
Okay, so the Eurasian trademark system also provides for the possibility to challenge a Eurasian trademark. It is possible already on the stage of examination. As I already said, there is an opposition period starting from the date of publication of the Eurasian trademark application, and any person may file an opposition within 2 months. There is further possibility to challenge a registered Eurasian trademark by the way of filing of an invalidation action with competent authorities of a concrete member state. In case this invalidation action in a member state is successful, so the Eurasian trademark will be held invalid and will be cancelled in the unified register of the Eurasian trademarks. In this case, the holder has the right to transform the Eurasian trademark into national applications in the member states. So, just summarizing this overview of the Eurasian trademark system, a few words about the actual status, but Yuri has already told about this. Now we turn to Eurasian Design Protection System. This system is a direct development of the Eurasian Patent Convention. The member states of the Eurasian Patent Convention adopted in 2021 a protocol on protection of industrial designs, and also a patent instruction to the Eurasian Patent Convention dedicated to industrial designs, and also the regulation of fees. So the system started functioning from the 1st of June 2021, so it is already possible to file applications with the Eurasian Patent Office to obtain Eurasian design patent. Actually, the protocol on protection of industrial design is valid for 7 countries. All member states of the Eurasian Patent Convention. Only Turkmenistan has to still ratify the protocol. In general, there are the following ways to obtain design protection in Eurasian countries. First of all, by the way of filing a national design application in a concrete Eurasian country. Secondly, this is a way of using the possibilities of Hague system of international registrations of designs. And the third option, which is now available, is the Eurasian design application in order to obtain Eurasian design patent, which is valid on the territory of all member states of the Eurasian Patent Convention, except Turkmenistan for the time being. So, according to the protocol, the Eurasian industrial design is considered as a solution of the outer appearance of an industrial or handicraft article. It is provided that an article can be a whole article, or an independent part of the article, or a set of articles. Also, packaging or typeface or label can be also claim protection as Eurasian industrial design. The most important thing is that the scope of protection of an industrial design is defined by the combination of essential features displayed on the pictures. So the scope of protection is defined just based on the pictures of the article. In order to obtain protection, a Eurasian design must be new. So this means that it should not be known from the publicly available sources in the world before the priority date. And it must be original, what means that the combination of essential features must have a creative character, and this means that there is no solution of an article of the same purpose and making the same overall impression on the informed user. But an important moment is that these main criteria, the compliance with this main criteria of patentability, novelty and originality, will not be checked automatically by the examination. And they will be checked only in case an opposition is filed by a third party based on these grounds, and only in frames of materials submitted with the opposition. The examination of the Eurasian design application is rather limited. However, there are still some grounds to be checked by the examination. First of all, non-patentable would be solutions which are contrary to public interests and principles of morality and humanity. This ground will be checked by the examination still on the stage of preliminary examination. And furthermore, the non-patentable would be the solutions including or imitating official state symbols or signs or official names or symbols of international organizations. However, in case a consent is obtained from these, from respective state authorities or from respective international organizations, so such elements can be included in the design as non-protectable elements. And furthermore, non-patentable will be solutions defined, which features are defined exclusively by technical function. So you have already probably the previous one. So these grounds for refusal that you see on this slide, they are checked by the examination.
Exclusively is very high criterion. It has to be just functional, not primarily.
Exclusively, yes.
So
Exclusively.
you can have something that's 90% functional, and it's okay.
It depends on the solution. However, I think the examiner will decide. And you probably have the right to submit arguments that the solution is not absolutely determined by technical function. So there are also further grounds for refusal which will not be checked automatically by the examination, but will be checked only in case an opposition is filed by a third party based on these grounds. So these are on the slide. So a few words about the filing requirements. Eurasian design application may include up to 100 designs, but provided they all belong to one and the same class of locality classification. An application is to be drafted in the Russian language, and it must contain the information about the applicant, the author, the title, the article, the locality class, the priority claim, if any. And it's also possible to submit a description of the design, but this is optional. A description can be filed just to explain to the examiner the purpose or the field of use of the design. And an application must also contain a set of representations. They can be made in the form of photographs, of drawings, computer-generated drawings, and it's provided that it's allowed to submit no more than 7 views for each design. So the procedure before the Eurasian Patent Office is rather simple. An application is to be filed with the Eurasian Patent Office. It undergoes a preliminary examination. In case the result is positive, the application is published. And an important moment here is that the Eurasian design system does not provide for deferment of publication. A design application is published after the preliminary examination in order to for opposition purposes. So any third party or a national office of a member state may file an opposition within 2 months from the date of publication. And after the preliminary examination starts the substantive examination, and the examiner also takes into consideration the oppositions if they were filed. So the substantive examination may result in issuance of a decision of refusal or decision of grant. The decision of refusal may be appealed with the Eurasian Patent Office and further with the head of the Eurasian Patent Office. In case of decision of grant and subject to payment of respective fee, The Eurasian Patent Office proceeds with registration and issuance of the Eurasian Design Patent. The Eurasian Design System also provides for temporary legal protection. This means that this temporary legal protection is provided in the period starting from the publication date of the Eurasian application until the publication date of the Eurasian patent. And it means that it is possible to claim compensation in case a third party used the same design in the mentioned period. However, in case the application is withdrawn or refused, temporary legal protection is not provided. The Eurasian Design System also provides for a possibility to challenge the Eurasian Design Patent. This is possible in two ways. The first one is initiating an administrative procedure against the Eurasian Design Patent with the Eurasian Patent Office. In case such invalidation action is successful, the Eurasian Design Patent is held invalid in respect of the territory of all member states. And the second option is filing of an invalidation action in a concrete member state and with the competent authorities of a concrete member state. In case such invalidation action is successful, so the Eurasian Design Patent is held invalid, but only for the territory of these member states where the decision of invalidation was issued. And the design patent remains valid in other countries, in other member states where the invalidation action was not rendered. So, and to summarize the overview of the design protection system, here you can see the key features of the system. I just would like to pay your attention to the fact that the applicants which are not domiciled in the member states, they must be represented by the Eurasian patent attorneys. In case the design application is refused, the applicant has the right to transform this application into national applications. There is also 12 months grace period for filing a design application. This means that in case of disclosure of information about design, this fact will not affect the patentability in case the application is filed within 12 months from the date of disclosure. The term of validity for a Eurasian design patent is 5 years and can be renewed for further 5 years, but the maximum term of validity is 25 years. So I hope this information was and is useful for you. So I pass the word to my colleague.
Now we have comparison of three systems that can be used over Russian territory, but I mean similar comparison we could prepare for any member state, but it's a comparison of Russian, Eurasian, and Hagi system to the extent of getting industrial design in any one of them.
Yeah, thank you, Yuri. Thank you, Viacheslav, for this introduction to the Eurasian patent system, in particular design system. So, good morning, everybody, again, and I will go briefly through all systems available for production designs in Russia since recently. The first one.
Mr. Levchuk?
Yes.
Your name is Ukrainian.
Surname, right.
Yes, surname is Ukrainian. I'm just curious as to...
It is right.
Yeah. But you live in Russia?
Yeah, I was born in Russia.
Okay, excuse me.
No problem.
Can it be also Belarusian name?
It could be Belarusian as well.
It's Russia is here, White Russia, Belarus is there, Ukraine in near the edge is there. So it's all about, you know, let's say something like international Russian or let it be in alphabetic order, Belarusian, Russian, Ukrainian community where everyone could be mixed with these surnames or with the names and that sort of things.
But I expected this question. One time. So there are three routes to proceed with designs in Russia once the applicant decided that he or she really wants to get his or her design protected in Russia. The first one is quite obvious. It's national route of filing a national Russian application, which is actually filing with the Russian PTO, and followed by formal and substantive examination with the office, and if successful, getting protection in Russia. The second one, which Viacheslav just told us, thank you for that, it's a regional route, quite a new one. This is filing a EuroAsian design application with the EAPO or Russian PTO. It will then undergo a formal and, let's say, limited substantive examination, and if everything is fine, the applicant gets protection in 7 member states, including Russia. And the third one, which is quite often used since recently, is international route, that is filing the Hague application designated Russia. In this case, the application is filed with the WIPO or national PTO. Formal examination in this case is carried out by WIPO, while the substantive examination is conducted by the Russian PTO. And again, if successful, protection is provided in Russia as well for this application. So since there are 3 routes and the applicant decides to get protection there, we have to help him or her to choose the proper one. So that's why I would suggest to focus on a brief overview of each of the systems, really briefly, and main concerns the applicant may face during prosecution. And last but not least, this price tag for this filing. So first one is the national route. So as I told, there is formal examination, which but others includes also classification that is designated a respective low-carbon class to the design claimant, and primary analysis on the unity. Unity is a big concern, and we will discuss it later on. Once the application has passed successfully formal examination, the applicant may request publication of the application to get a provisional protection for the design claimant. So enforcement is limited to the compensation only or monetary remuneration in this case. And as I told, substantive examination is provided during the course of examination in the Russian Patent Office, and when it's successful, then the patent is granted. So main concerns which the applicant may face too in this way. First of all, to mention is strict approach to unity of the designs claim and the variants filed in one application. Later on, I will show you real-life examples and maybe explain better to understand it. So second concern is that, which is often appeared, is that trademarks of third party on designs claimed are by no means allowed on the figures of the designs. And in this case, the letter of consent is not accepted at all. There are some limitations to what can be filed in one application. For instance, it's an article and a part thereof. I will show that example again later on. So there are some requirements to drawings, to ornamentation, to logos. For instance, logo shall comprise text by definition, and drawing is considered to be not a label, and therefore it shall designate the article it belongs to or can be applied on. Last but not least, it's a bunch of formal yet strict requirements to images. I will show you again one example later on. Now about the regional route, just very briefly, after previous talk, the application undergoes formal examination, then it will be published to get provisional protection and also for filing oppositions, if any. And substantive examination is carried out on patentability only if objections filed and only, or third-party opinions filed, and only in the frame of those grounds and prior art documents which are mentioned in this objection of third-party opinion. And if everything is okay, protection is provided in 7 contracting states of the Eurasian patent system. The concerns are somewhat different to those, next slide please, of the regional route. First one is that the publication cannot be deferred at all. So for some applicants it's a real concern, real problem. Second thing to mention is that the fees for the Eurasian application are much more higher. So this application is much more expensive in terms of fees than the national route selected. For instance, if you take an application comprising only one design, the difference is set 6 times, roughly. If we file 5 variants in one application, the difference may be 10 times and even higher. So, on the other side, you can file a number of articles in one application, up to 5 articles. So, it means that you can file a design and a part thereof in one application, in 4 parts. And, well, yeah, it's limited up to 100 designs, but still these are 100 designs of the same Locarno class in one application. You can get protected with 1 patent. And the international route overview, common examination, formal examination by the WIPF for all the contracting states, followed by substantive examination conducted with the Russian PTO, which governs the main concerns for this way as well. The application will be published while deferment is still possible, and this provides for provisional protection in the territory of Russia as well. So as I told, the main concerns are same for national route because of substantive examination is conducted by the Russian PTO. Deferment is possible but limited. Other concerns which we have experienced for our clients are the following, and very specific for the international application. No office sections are issued, and this is provisional refusion only for unity objection, which is issued by the Russian patent forces. In all other cases, the Russian patent office issues full refusal. It means that it can be appealed, but with the Chamber for Patent Disputes, which is way more expensive than answering a typical office action, which would have been issued by the Russian patent office if a national application was filed instead of international. And one thing to mention as well is that all the documents which have to be provided to the Russian PTO, such as priority documents or right transfer documents, they shall be filed directly to the Russian PTO. It can be done by the applicant, him or herself, but in that case, they will receive no confirmation on receiving of these documents. We did really experience some problems with submitting these documents and no confirmation from the Russian PTO. After which the application was rejected. So now a number of some examples which will help you to understand what is the main concerns for each and every route. So this was the label originated from the Hague application. The number is given. So it was rejected by Russian PTO. It was filed through the Hague system and was rejected by Russian PTO. The reason was that the label, according to Russian regulation, shall comprise boundaries. The way to overcome this objection would be, possibly, but quite likely, is rename the design, for instance, like drawing for label, or ornamentation for label, or drawing for particular goods, or a class of goods. But still it's questionable because in this case they had to reassign a new Locarno class. National route, it would be objected, not rejected completely, but would be objected, so the applicant would have a chance to answer this office action. And as regards to Eurasian patent office, it would be allowed without any problem. Next slide, please. So another example. Now, is the same. It's Hague application ornamentation. So it was rejected in Russia because of the following reason. Ornamentation shall refer to the article it belongs to or can be applied on. But just changed the name of the application to ornamentation for back. It's for light. So it's for backs. And afterwards protection was granted. But we did it in the chamber for patent disputes. Not was that a kind of answering to the office action. It would be the same for the national route, for filing Russian application. Apart from that, it would be a regular office action. And the regional route, it would be allowed without any hesitation problem, which is shown on the next slide, where a simple ornamentation, just ornamentation, was filed with the Eurasian patent. The number is given there. And as I told you on the previous slide, in the other two routes, it would be rejected or objected. Again, one has to change the name of the design claimant. Quite simple, but you know this step requires some money for the applicant to spend. The next one, please. Logo. In Russia, it is obligatory that the logo shall comprise text. This logo did not comprise text. That's why this international application was rejected in Russia. It would be rejected if it filed as a Russian design application as well. But it would be allowed in Eurasia. Next one, please. So this is two different designs which could be allowed in Eurasia. It's packaging for food products. You see it's a box with a logo and logo itself or label itself. So it would be allowed in Eurasia, but it would not be allowed in Russia, whether it's national or international application, because the examiner would say that these are two designs providing for different scopes of protection. One is the package and another one is the logo or label. Variants. It's a big issue in Russia, really. Very strict approaches. Variant 1 would not be allowed in one application with the rest of three variants, 2, 3, and 4. Again, these variants, variant 1 and the rest of variants, provide for different scope of protection. Therefore, they shall be filed in different applications. Contrast to that, it could be filed and granted in one application filed with the Eurasian Patent Office. And finally, one more example on how they treat drawings or images in designs. You see that was also an international design application, part of liquid pump, and a part of variants are given as 3D models, and the rest of part variants are given as graphical designs. This would be allowed in one application of the Eurasian system, but would not be allowed in international route and national route. The applicant would then have to split this into applications, at least. So, the bottom line is Eurasian system provides for more opportunities for the applicant to proceed with their applications. And the only two concerns which one should keep in mind is price tag for that, and the second one is that publication cannot be deferred. Thank you.
Thank you, Denis. Maybe some questions while I'm changing the flash memory. So, Eduard, this is your time.
Thank you very much. Well, I'd like to first thank my colleagues for giving us insight about
EuroAsian system. I'd like to thank Viacheslav and Denis for giving us information about currently working industrial design system in Eurasia, and also giving us some prospects about future. I hope so that it will be also launched in the near future. So the future regional trademark protection. So, but I would like to go through the Eurasian system from the perspective of inventions. As Yuri has said in the very beginning, the Eurasian patent system, patent organization, which was established based on this system, is initially was focused on protection of inventions. Now it operates for 8 member states with a total population of 208 million people and the overall gross domestic product of 1.8 trillion US dollars. For the 27 years of its existence, the Eurasian Patent Organization received more than 67,000 applications from 130 countries. By now, there are 40,000 patents issued, and 18,000 actually are still valid. Every year, Eurasian Patent Organization receives about 3,400 patent applications, and last year, 92% of them have been filed electronically. Eurasian patent system is very much demanded by foreign applicants. 75% of applications last year have been received from foreign applicants. 30% of all applications are received from the United States. So probably it's about 1,100 applications last year were received from the US applicants. Foreign applicants can file in Eurasia through conventional route or through the PCT route, which is obviously more demanded, more popular. The filing fee for 5 claims, which is flat fee, is about $600 US as on July 2022, when fees has been increased. And the examination fee for first independent claim is about $650 US. So usually when it, previous slide please. Usually when it comes to the average application for having 25 claims and 2 independent claims, the filing fee is about $2,200 US. But at the same time, the applicant, when they file Eurasian application for an invention, they receive quite the benefits, because they can file one application which is valid in 8 countries. They can go through the single examination procedure, pay one bunch of fees, cooperate with only one attorney, and the examination will take place in one working language, which is Russian, as we know. Thank you. So once the examination is passed and examination of merits is successfully passed, decision to grant is issued, and there are to get the patent rights, the applicant, as we already previously said, should not pay validation fees. And Eurasian patent remains valid in those countries where the maintenance fee is paid. So, and even if there are some problems with paying the annuities, the restoration of patent is possible within 3 years from the date when the patent was deemed to be lapsed. So even if there are some circumstances that gives no opportunity to a patent owner to pay annuities, he or she still have the right to still have some time to restore the rights afterwards. Well, the Eurasian Patent Office is open to receive applications for different objects. If we're speaking about inventions, it's a device, method, substance, biotechnological product, or the use thereof. The invention, there are three usual criteria of patentability for invention, which are novelty, industrial applicability, and inventive state. Next slide, please. But there are also some exclusions from patent eligibility, which are, among others, discoveries, scientific theories, methods, computer programs, for example, or any solutions that relates to representation of information only. But it have to be mentioned that these subject matters are not regarded as inventions, only when a patent application relates to this subject matter as such. So this is quite a similar requirement with those our European colleagues have in their jurisdiction. So, for example, it's also important to note here that the eligibility assessment starts from the generic term of the claim. So if, for example, anyone claim a computer program and it's a generic term of the claim, then it will be rejected as being non-invention under the Eurasian Patent Convention. In these situations, when the application allows this, we suggest amending the generic term, for example, to be non-transitional media, computer-readable media, storing the computer program, and in this way the eligibility assessment will be successfully passed. So the Eurasian Patent Office also suggests and allow applications to use benefits of acceleration procedure. EAPO recognize working products of Eurasian Patent Office, Japanese, Chinese, Korean, and Finnish Patent Office. So if there are applicants who have previous examinations made in this particular patent offices, and there are some working products, even if there is, for example, a decision to grant with at least one claim allowed, then they can file for PPH in Eurasia. Looks a little bit strange that, among others, there are no USPTO because, as I initially said, the US applicants are very active in Eurasia, but still the process is ongoing, and EAPO is trying to develop cooperation within the PPH program. So there are two ways. Once you get the patent, you have to know about how to protect it, how to enforce, and how to invalidate the patent of your infringer, for example. So there are two ways of invalidation of a Eurasian patent. The first one, which is very rarely used, for 5 last years there were only 13 cases, is administrative nullification action, which take place in Eurasian Patent Office. The objections based on this nullification may be filed within 6 months from the date of publication of the patent. There are reasons, different reasons for a revocation within this procedure, which particularly comprise the lack of novelty or inventive step or industrial applicability. Also, there is a reason, another reason may be, for example, lack of sufficiency of the disclosure. The objections, as I said, are considered in Eurasian Patent Office, and if revoked, a patent is considered to be never came in force in all the member states. The other way is when the 6 months have passed. The other way is nullification in National Patent Office of member state. Next slide, please. It may be revoked within this procedure during the whole life of a patent. The reasons are quite similar with those that can be used during the administrative nullification. For example, lack of patentability, as I said, lack of lack of sufficiency of the disclosure. The objection is considered in the national office of a member state. And if a patent is nullified, then it is considered to be invalid on the territory of a particular member state. To summarize, well, the Eurasian system is a cost-effective way for patenting an invention if you if you are interested in at least 2 countries in the region. So as far as we may assess, it is more cost-effective. Starting from two countries, it's better to file Eurasian patent application rather than 2 national. There is acceleration opportunities. There is a fast examination. The average term for examination is about 17 months in Eurasian Patent Office. So one patent attorney, one bunch of fees, one IP legislation for all member states, and last but not least, very applicant-friendly environment. The Eurasian Patent Office in particular offers a developed electronic service. So yeah, probably that's it. That's short about what is the EPO for inventions. I'll be happy to answer your questions. Thank you.
Yes, thank you. Thank you all. If any questions, we can try answering them. If not, we are available for the rest 2 days, and feel free to ask us. Thank you very much. Oh, yes.
Could you comment briefly on the enforcement procedures, how dependable and effective and expensive are the enforcement in a court proceeding, I presume?
Who will do that?
You can start.
Yeah, please.
Well, the Eurasian patent should be protected in each particular country. So you have to collect evidences that your patent is infringed. Well, basically the infringement process in a court is quite a costly procedure, certainly. As about the costs itself, maybe my colleagues will help better with this. But the procedure looks pretty like this. So you have to protect your patent in each particular country. But the thing is that, well, probably it's the same like protecting the local patents, national patents. So pretty much the same procedure.
Yes, it's all about national proceedings through national courts, and of course you felt that there may be a problem because the level of let me start from the nullifying patent. After the administrative nullifying has expired, the 6-month period, then it goes to the national, as it is written in the convention, administrative and or other authorities. And here the main problems come first because they should apply Eurasian legislation. And let me say, even Russian courts have difficulties, and we saw that had difficulties with applying the Eurasian law to the cases with the appeals against the grant of the Eurasian patent with regard to Russia. And certainly when it goes then to the national levels, where comparing to Russia there are very few, if any, infringement cases, it's quite difficult. This is why new Eurasian president, the former commissioner of the Russian Patent Office, is one of the, I would say, strategic idea is introducing Eurasian Patent Court to apply in a unified way the Eurasian legislation both to appeals and to infringement cases.
Maybe I have 2 questions.
Yes, please.
Maybe the first one would be the extension of the first question that you asked. Do you have any statistic on the litigation? For instance, who litigated, and also at the same time how many litigation you have, and the extension of the, I'm sorry.
You mean generally or with regard to Eurasian patents?
With regard to Russia.
With regard to Russia.
And then if you have some statistic on the Eurasian patent, that would be good too. So this is a kind of statistic numbers that you have, in mind. This is the first question.
Yes.
The second question is about the licensing, and especially the compulsory licensing or mandatory licensing. Do you have any framework for that, and how does that work?
Yes. So, anyone wants to comment? Then I will try to comment it. Starting from compulsory licensing. The compulsory licensing is defined in almost all the legal acts of the... let me first define the terms of my response. So I am telling you about the Eurasian system, about the member states of Eurasian system. The compulsory licensing is defined both on the Eurasian level and on national level. And usually the countries apply almost similar conditions for compulsory licensing, meaning that for compulsory licensing eligible are patents that are not used for a certain time frame, and during this time frame it is definite that there is lack of offer in the market of the patented articles. So the compulsory licensing first is always a litigation in which one party which wants to get a license shall show that it tried to do that, negotiated that license but failed, and the court shall decide whether there are circumstances defined in the law are true. There is low demand of the goods and services patented by the protected by the patent, and then if the circumstances are proved, if the court decides that this is the case, then the compulsory license is granted. It is not exclusive license, and it is granted on the average terms existing in that field of art, which is invention protected by the patent. With Eurasian Eurasian system happened a story which probably is known to you, where 6 patents belonging to Gilead company, the right to use them was given by one company, Pharmasynthesis in Russia, for medical, which is remdesivir. And that was very, I would say, mysterious story, because, it was just commented that the rights were granted to use for 1 year, and then was extended for one more year. If we try to recapture this story by by combining it from pieces of information available in various sources, it may be reconstructed as Pharmasynthesis and Gilead had a contract for joint development of the facilities for manufacturing remdesivir. And then for some reason it looked like Gilead wasn't willing to continue those project. And it may happen that this project also involved certain governmental financing. And therefore, to continue that, and remdesivir was medical with, as the WHO organization said, with questionable effect to the extent of applying it for COVID-19. So it's more about another situations. So it was granted, and it was used for 1 year with extension for another year. With generally averagely defined remuneration. So just to summarize, the compulsory licensing is available. It always a litigation, during which an interested party should show that it contacted the patentee, failed to reach the agreement, while the patentee is not using or is insufficiently uses invention protected, what leads to lack of market offer. And second question about the figures. I'm not sure we can reveal figures from the member states because it's very difficult to. I would expect that there are very low figures in the member states of Eurasian Convention, with the exception of Russia. In some countries there may be zero, both national and Eurasian. In Russia we have growing number of litigations on patent infringement, on invalidation of patents. As you may know, we have the Court for IP Rights, and Mr. Rader visited, I think, several times this court, and the court is functioning. We're happy as the practitioners that it is a specialized court, and I think that if I say that there are around 300 cases per year for patent infringement on various stages of the court proceedings, I will be about the correct figure. And very few for Eurasian patents yet, but I think that it will be raising. Because, well, we all know the situation with the Ukrainian-Russian tensions. It, in the patent field, it had its consequences where people willing to get protection in Russia in the time of uncertainty with license 13 of the Federal Treasury of US and other like situations, they switched to Eurasian system and getting protection in Russia, not by direct filing in Russia, but by filing through Eurasian partners. So the number of Eurasian applications is now growing up. Thank you very much for your attention, and ask us later. We all are here up to the end of the conference. Thank you very much.
Thank you so much, Mr. Yuri. That was such an insightful discussion. Can we have a huge round of applause for all of them? Thank you so much once again. I request Mr. Yuri to please present the mementos to our speakers. I request Mr. Rybchak to please come here. So, if you can just present the memento. Let's give him a huge round of applause once again. Thank you so much for your insight. Oh, you wanted to take it here? If you can just come here because that's a better...
Stand in a different place.
Here?